recognize myself for questions. And first of all, Governor, you had asked that consent decrees and institutional reform litigation strategies for state legislatures be entered into the record without objection, but for transparency's sake, I must confess that I am a co-author of that report. So, one of the points I want to make here is that we're not arguing that all consent decrees are bad. In fact, consent decrees are a legitimate and useful tool in the legal system. They've proven so in both public and private cases. The point and focus of this hearing is the abuse of consent decrees. And I think we got a little off track on that, particularly when they are used to circumvent the legislative process, which denies citizens their right to governance through their elected representatives. It's particularly egregious in the direct manner in which they bind state and local governments in administering their programs and allocating their resources. Illinois is a prime example of this. They're currently under 80 consent decrees, some dating back to the 1970s. And just from your perspective as a former governor, having served in elected office, and I also, for transparency's sake, I've known the governor for 20 years. You want that transparency and that accountability to the voters, which is denied them when they're under a consent decree, and particularly when the consent decree is being administered by an unelected judge, an unelected control group, unelected bureaucrats, an unelected special master. Is that not problematic for representative government?
Oh, that's exactly right. And there simply is no accountability there, at least no accountability back to voters. And we haven't talked about the role of monitors either today, but the federal judge is appointing somebody to kind of be the master to oversee. And in the case of the ongoing litigation in Michigan, there's somebody that's reporting every 6 months back to the federal judge. Now, the criteria for picking the monitors is sort of in the province of the federal judge. That's often, I suppose, a qualified university professor, or there's a little cottage industry of monitors that are out there. But the reality is that when there's 211 sort of factors that are being monitored, there's not much discretion left for the agency head or the legislature to set priorities or adjust priorities as new information becomes available, new technology emerges. One of the boondoggles that's been out there in the child welfare world has been the whole SACWIS implementation. Dr. Sanders is very familiar with this, but I mean, states have spent literally tens of millions of dollars trying to meet a federal mandate there. This is on data collection, and the way this has been done, I would advise nobody to ever do a data project that way, but I faced that situation, and by the time I was elected, we were several tens of millions of dollars into the project. It would cost many more millions to start over, and it was going to cost many more millions to finish. We simply slogged on to try to get that done. It still wasn't adequate. And yet that's the kind of micromanagement you're getting. Another area where in a lot of this area, and again, Dr. Sanders' testimony is important, especially when it comes to children and children's welfare, the cross-agency cooperation and collaboration that's necessary today often is precluded by the very federal laws that are passed here. They don't allow the flexibility to bring the mental health services, the public health services, the education services all together. And in fact, each of the programs often has their own administrator when we'd be better off. I've said you have to be very smart sometimes to be trapped in poverty because you've got so many different agencies with so many different programs who want to look out for you, and we ought to be able to literally appoint an individual who could draw all the services together.
Well, in Dr. Sanders' testimony, he mentioned a couple of cases, Alabama being one of them, RC versus Hornsby, in which we were able to work through a consent decree to a reasonable solution. But there was another consent decree in Alabama involving the State Highway Department in which we literally spent enough money just on legal fees to repave every mile of interstate highway in Alabama twice. And for those who don't think we have paved roads, we've got lots of paved roads. That's the problem, is the ability to work your way through these, and Dr. Sanders' testimony particularly, I think, is relevant in the area of children, that as science changes, as techniques change, those aren't taken into account. I just, Dr. Sanders, I'd like to know, have you seen circumstances where full compliance with a consent decree is impossible? And I'm thinking of New Jersey, which has been held up as a model, but they're still under a consent decree.
Thank you for the question. We actually, in one of our convenings, had a data expert from Emory University take a look at some of the agreements and found that it was impossible to achieve all of the measures that were required at the same time. And in part that happened because the negotiations for the consent agreement weren't made with data experts. They were made with attorneys, and they weren't familiar with some of the measures. And so it would not be possible for some states to exit given the current measures.
Thanks, Dr. Sanders. Mr. Gefkin, who filed the suit against Fort Smith?
I believe that actually came from the state and EPA.
Okay, so
against the city in order to make the city of Fort Smith compliant regarding sanitary system overflows.
And you believe they were trying to make an example of Fort Smith?
I do, based on the information I've just heard from Representative Gianforte. Yes, that was unknown to me when I went there. I knew we had a large problem, and I knew it was being addressed by spending several $100 million. Again, the whole process of a consent decree ties one's hands, and you're not able to apply the latest technology or focus on actually what yields the best benefit.
How much did you say this is costing the residents of Fort Smith? Say an average household, what's it?
$15,000.
$15,000, and the median household income
$33,500.
$33,500. This is one of the examples, again, where overregulation and the abuse of consent decrees does great harm to low-income people. I grew up in a pretty much dirt poor. My dad had an 8th grade education. It would have been staggering to us to have had to have the type increases that in sewer payments that you guys have had in Fort Smith, or that we've had in Jefferson County in Alabama and Shelby County. We're going through the same thing, and it's had a negative impact on the ability to grow the economy. And just to give you an idea of how overregulation harms the economy, Gallup put out a report, pointed out that prior to 2008, there were 100,000 more businesses starting up than were closing. By 2014, in the United States now, there's 70,000 more businesses closing than starting up, and the primary problem is regulation. So one of the problems that we point out in that paper that Governor Engler cited is the inability to track these consent decrees. We went to the Justice Department, we went to the Judiciary to try to see if they categorize these in such a way that we could look at Arkansas or look at Michigan or the state of Washington and determine, what consent decrees apply to those states, the state or local government. They don't track it that way. So I would ask Dr. Sanders and Mr. Weissman, should Congress consider legislation requiring federal agencies, particularly the Justice Department and the Judiciary, to track and categorize and publish a list of these consent decrees? Dr. Sanders? We
found with the child welfare consent decrees that there actually wasn't any single place where the information was captured, and so we've started to do that just based on the convenings and discussions with states. That presents a number of issues, and it seems that it would be a good direction for Congress to take a look at a minimum tracking the consent decrees as well as the cost and the results.
Mr. Weissman, would you have a problem with the federal government tracking these and publishing a list so that they could be easily identified?
No, absolutely not. I think that would be highly desirable. I think, there's some difference between the consent decrees where the federal government initiated the case versus where a decentralized thing by a citizen group. So the second would be harder to compile, but would be desirable in any case.
Well, it really wouldn't, because if the federal government entered into a consent decree, it doesn't matter who initiated the suit. It is a matter of tracking these so that there is a concise list. Governor Engler?
I think the courts also ought to have an obligation here. There ought to be something in the judicial system where each of the, I don't know if it's the circuit court who oversees the district courts in their region, you know, whether the circuits would have it, or somehow the court administrator. The federal judges ought to know how many consent decrees they're actually enforcing in their jurisdictions, and that may be an easier way to get it than trying to go to the agencies, and because who knows? But there's a limited number of federal judges and federal, you know, circuit courts, and maybe that they should know their caseload. That's part of it.
I'd like to thank our witnesses for taking the time to appear before us today, and I particularly like to thank the ranking member, Ms. Demings, for her indulging me going a little bit longer. If there's no further business, without objection, the subcommittee stand adjourned.